Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Yes, as you can hear in my voice, I'm still battling allergies. I just cannot get over it. So I'm sorry you have to bear with my voice yet another week of sounding like this, but here we are. So today's episode is a cautionary tale where we talk about real life cases with real life clients and real facts. There are things me or my office have actually worked on. So for today's episode, we're going to be talking about a few different stories. They are cautionary tales involving real estate. And you see, real estate just works a little differently than other assets. And you'll see that play out in some of these cautionary tales, that people think that real estate works similar to owning, say, like a bank account jointly, but it does not. So let's just dive in, shall we? And before I dive in, I should just also clarify that if I happen to cough, I'm so sorry. I hope I don't come through your speaker too loud. Okay, so the first story is the most recent one. So this case actually just landed in our office like a month ago. And we got a call from, let's call her Sally. Sally's dad had passed away. And as she had explained it, she, quote, only put his name on the house because the bank was concerned with her low credit score. It was, by most people's account, her house. He did not live there. He did not even help with the bills. Though on paper, that house and the mortgage was technically just in Dad's name. I'm sure you know where this story is going. Just given what we talk about here on Legal Tea. Dad passes away. Instead of going to see an estate attorney, Sally just kept on paying the bills and living there. Well, and here's where this story gets a little extra weird. The house catches on fire, and it's nearly a total loss. Of course, the insurance company gets involved, and that's where Sally starts connecting the dots. Because the house is in her dad's name, the insurance company is only willing to pay Dad's estate, which would be governed by Dad's will, or if no will, then the state's intestacy laws, which are like a default estate plan for people that don't have a will. At this point, like I said, this is a really new case, and we don't believe that Dad has a will, meaning that his estate will go to his 4 children. So the proceeds from the insurance company, for Sally's house, said in air quotes, will be split between Sally and her 3 siblings. Ruh-roh. So we immediately thought, okay, Sally, do you think your siblings would just say, hey, we don't want our share? And that's called disclaiming. Disclaim their share of the estate, the house, the insurance proceeds. At that point, Sally looked up at me and said, Jenny, one of them would probably just, disclaim it in a heartbeat. Her and I are super close. But the other 2 are a big old question mark, because one is in jail and the other one is sort of estranged and lives in Mexico. I thought to myself, but clearly did not say out loud, oh no. So we'll see how this cautionary tale plays out. It's, like I said, like I've said a couple times, it's a very new case. So to even guess how things go, because Sally's sibling who is incarcerated, and then the other sibling who's estranged and live in Mexico, they're sort of wild cards at this point. Nonetheless, the point being, Sally and her dad should have paused when they were going through the real estate transaction to make sure they were setting things up well. Then, once the real estate transaction was done, Dad should have ensured his estate plan supported what he would have wanted to happen, which likely would have been to transfer ownership at his passing of this house to Sally. Are we ready for a second cautionary tale story about real estate? Let's go. Let's name this client Beatrice. Old Beatrice had a friend who, quote, lost everything to a nursing home. So to protect her and her family, she transferred her house to her 3 children. When I say transfer the house, I mean she literally deeded the house from her name to her children's name. Fast forward some time, then bam, her magnificent plan went sideways because one of her children passed away. And to clarify, Beatrice and her other 2 children were still living when this happened. You see, the thing to take away from this cautionary tale, this story, is that property like a house, land, farmland, etc., we call that, quote, real property in lawyer world. That real property just operates differently than most assets. So you compare like a joint bank account. If one of the joint owners passes away, the account naturally and legally defaults in ownership to the surviving joint owner. That is not necessarily how real property like a house works. Instead, property gets transferred totally how the deed is written up. And all too many people try to whip up deeds without professional guidance, and they get themselves in trouble because they don't know that there are different types of ownership. And those different types of ownership play out very uniquely and differently if an owner passes. So like in Indiana, and I assume in many other states, there are generally 3 types of property ownership for real property. And let's run through them super quickly. First, joint tenants with rights of survivorship. This means that 2 or more individuals own the property, and if any of the individuals passes away, the property stays with the surviving individuals. So say if we have Bob, Tom, and Cliff as joint tenants with rights of survivorship, and Cliff passes away, well, Bob and Tom own the property now. It doesn't go, like Cliff's interest doesn't go through his estate plan or anything. Second is tenants by the entirety. And this operates just like that last one, joint tenants with rights of survivorship. But this tenants by the entirety is exclusively reserved for married couples. So say Bob and Mary are married. Mary dies. The property automatically stays with Bob. So sometimes on a deed, it merely says husband and wife. So if so, in Indiana, it's presumed that it defaults to this tenants by the entirety classification. And third, finally, this means that it's called tenants in common, and this means that every owner owns a respective interest. So say we have Bob, Tom, and Cliff again, and they own a property as tenants in common. Bob owns a third, Tom owns a third, and Cliff owns a third. Cliff dies. His 1/3 would be distributed according to his estate plan, meaning if his will left everything to his spouse, well, that means that Bob, Tom, and Cliff's spouse are about to become owners together. The kicker with all of this is that if a deed is silent, so say it just says Jenny and Tom, and it doesn't have any classification after it. It doesn't say anything. It just says our names. That defaults, again, here in Indiana, it defaults to tenants in common, which is kind of odd, right? So say someone pulls a deed off the internet and just puts a property in their name and another person's name that's not their spouse and does not put any classification. The law presumes it's tenants in common. And that is exactly what happened to this client, Beatrice. Beatrice transferred her house to her 3 children. They didn't put any classification as to how she was transferring it to them. So it defaulted to tenants in common between the 3 children. So as I stated before, one of her children passed away after she transferred the house. And guess what had to happen? I'm afraid to tell you. Well, that child, legally speaking, owned a 1/3 interest in Beatrice's house. Because the child passed away, we had to probate the 1/3 interest to get it back to Beatrice and her 2 living children. The deceased child was married, had children, etc. So because his 1/3 interest had to go according to his estate plan, which left everything to his spouse, his wife, thankfully, the spouse of the deceased child agreed to disclaim her interest and let it pass back to Beatrice and her 2 living children. And please note, she did not have to do this. She could have caused a ruckus. However, where the story stinks is that for probating the deceased child, like Beatrice the child that passed away, for probating his 1/3 interest, they had to hire an attorney. And they hired us to get it straightened out, which was legal fees. Okay, a third and final cautionary tale before we wrap up. This one sure left me scratching my head when I heard what happened. So we met with a lady, let's name her Dorothy, that during the conversation, she brought up a piece of property. And I think if I remember correctly, it was like a parcel of farmland. So Dorothy proceeds to share that many years ago, her and her now deceased husband purchased the property from a neighbor. And they thought, oh, they don't need, any of those silly lawyers involved. We've got this. So they gave the neighbor money for the land, and the land was theirs. So she thought. At that time, Dorothy shared that they were unsure how to title the property. Should they put it in both their names, just one of their names, and their kids' names? They went into what I like to call analysis paralysis, where someone stews about something for so long that they freeze. They don't move. And that's exactly what happened. Life must have gotten in the way because they never actually transferred the property into their names. You heard me right. So immediately we asked Dorothy, okay, so what's up with the neighbor now? Are we still cool with them? She responded, oh, they died many years ago. We were like, what? Well, to keep a long story short, since the property was technically in deceased people's names at this point, the neighbor's family had to open probate to have the legal authority to sign the deed to transfer the property to Dorothy. While they were agreeable, thank goodness, they basically told Dorothy that they'd be agreeable to signing it over if she paid the entire bill for the attorney. Essentially, they were like, yeah, sure, we'll be nice and sign it over, but you're going to foot the bill, not us. So that's exactly what ended up happening. We had them all waive a conflict of interest since it was kind of a weird case. And we opened probate for the neighbor and worked with all of them to clean everything up. And that reminds me of something that a friend who is a realtor by trade said to me once before. They said, I don't understand why people are so careless with property. Oftentimes, a house is someone's biggest asset. Heck, if you have farmland or rentals, it just amplifies this point. So why do people not get professionals involved when doing property transfers? They're so right. People do their own deeds that they pull online or they pull from the county recorder's office. And if they do it wrong or assume something that is not accurate, they have no idea the consequences of their action. Whether it be a consequence that they deal with in their lifetime or their kids' or beneficiaries' lifetime. If it's not done right and it's not done well, someone will have to clean it up eventually, either you or them. I think all three of these stories exemplify that to a T. Alrighty, let's wrap this episode up and shift to a sneak peek of next week. So we are back to the current events, current trends topic, where we talk about something I've seen or run across, maybe on the news or social media, that I think would be interesting to chat about on here. During next week's episode, we're going to be talking about something a little unique. I had a client recently share with me about human composting and water cremation called aquamation, which may make some a little squirmy. But since this podcast talks a lot about what happens when we pass away, I just think it would be interesting to talk about this, these new trends in the post-death space called human composting and aquamation. So that's what we're going to talk about next Tuesday, Legal Tea listeners. So until then, take care and be well.